All right. We have one counsel. We have Mr. Ambler. Is Mr. Howard with us today? Or Mr. Ambler, will you be making argument?
I'll be arguing, sir.
Okay. And Mr. Ambler, how much time would you like to reserve for your rebuttal then?
5 minutes, Your Honor.
Okay. Thank you, counsel, and you may proceed.
Thank you very much, Your Honor, and may it please the court. Judges, I am here today to argue on behalf of the appellant Ambler Law Group and Kevin Ambler on a non-final order that approved a confidential third settlement in a medical malpractice case. The case, just by way of brief facts, arose back, or representation began in the case back in April of 2011. The medical malpractice claims were investigated through June of 2013, and a suit was filed in that year. In July of 2016, there were 13 defendants, and a settlement was reached with a couple of those defendants involving an individual and an entity he worked for. And that settlement was approved by the court in July of 2016. That's at your appendix 158. Subsequently, the case was set for trial. And in October 2017, the appellee had notified the Ambler Law Group that it was terminating representation in the case. Thereafter, on November 15th of 2017, the trial court entered an order substituting counsel, and the case proceeded. There was very limited discovery. Expert reports were already issued in the case prior to the termination of representation by Ambler Law Group. And in March of 2018, a second settlement was entered into.
Sir, I'm sorry to interrupt, but you can use your time however you want, but we are familiar with the facts of this case.
Let me go right then to the issues before the court. In summary, this is one of those instances where, to use the euphemism, it was a cart before the horse. The court conducted a hearing on June 25th of 2020, in which in attendance.
That was the hearing to decide whether to approve the settlement?
Yes, ma'am. The confidential third settlement in the case. The important point for the court, as noted in the reply brief, is that there was a confidentiality order already in place that the court had entered in May of 2020, which permitted the Ambler Law Group to share in confidential information on the case, attorney-client privilege information, and a variety of other issues. And
well, your complaint is that you weren't able to participate in that hearing, correct?
That's part one. Part one is we weren't able to meaningfully participate in order to object because we didn't know what the terms were of the third settlement that was being proposed to the court. But more importantly, the court entered an order on June 26th of 2020, and that by that order, the court authorized disbursement of the funds.
But that was the disbursement later. That was changed, wasn't it? Isn't the money now being held in trust?
Well, that point is a bit unclear. The disbursement of whatever is there may be held in trust. That concerns the first and the second settlement. So there is the matter of approximately 1.5 million that was already being retained in trust in the trust account for the Ambler Law Group and for the trust account of the substituted counsel for appellee. But the amounts for the third settlement are unclear whether those are in trust or whether there are sufficient funds in trust. And that goes to the core issue here, is that there was a predetermination that the amount being withheld was sufficient to cover charging lien that has never been adjudicated and gone to a final evidentiary hearing.
But that was based on your stipulation as to the appropriate amount to be held in trust, wasn't it?
No, ma'am. We did not stipulate to an appropriate amount.
You never said.
Go ahead.
You never said that 1,300,000 was enough based on your calculations?
No, I would refer Your Honor to the appendix, page 257, where counsel for Ambler Law Group points out for the court. This is in the transcript from that hearing.
Which hearing? Which hearing?
Yes, this is the hearing on June 30th, 2020. It was the hearing for reconsideration.
Well, that was later.
Yes, that was later.
Originally, you submitted, I can't
the-
recall offhand when it was, but at some point you said 1,300,000 would cover your attorney's fees. Now you are arguing that that was just a preliminary determination, and you've done more calculations, and now in your view there should be almost 3 million held in trust. But originally you said 1.3 million, didn't you?
What was said was there was a preliminary calculation. The calculations were still being determined in terms of the amount of hours, and in the early filings there was a preliminary determination of 1.3 million. That was later revised. And I point out to the
when was
court,
that? When was that later revised? Did you filed a motion to?
There was a motion for enforcement of the charging lien that was subsequently filed in May of 2020, in which those numbers were clarified from the original numbers of 1.3 that were filed at the notice of charging lien.
Was that after for some reason I can't find the dates
That was
in my
before
notes.
the hearing. That was before the hearing that was conducted on June 25th. There was a
Okay, so that was-
motion for enforcement that was filed in May of 2020, a month before the hearing that the court conducted. And I would point out for the court that, by this court's, the Supreme Court has held very clearly in the Shearsey et al. Versus Pollitt's case from 1995 that charging liens are determined by the totality of the circumstances for quantum merit, not just based on lodestar. And in this case, the quantum merit.
There's nothing that's occurred that prevents you from litigating your charging lien, is there?
The issue is not whether we were prevented from litigating the charging lien. The issue is whether the fund that should have been impressed and frozen is sufficient to adequately protect the charging lien prior to there having been an evidentiary hearing and final determination of what the amount of the charging lien is. And in this instance, we're arguing that there's a form of prejudgment that's occurred in looking at the numbers of what's already was in trust and not knowing what the amount of the third settlement was. And the court—
Yeah, but all the court did was just approve the settlement, correct?
No, the court approved the settlement and ostensibly a disbursement of some of the funds. The issue that we raised in argument for
but as I understand your issue, you are arguing that you should have been able to object to the settlement.
Yes.
That has nothing to do with preserving funds to satisfy your charging lien.
So let me elaborate on that, Judge Kelly, because that's a great point. And here is how it ties into the due process argument on the opportunity to be heard at the June 25th to 2020 hearing. The point is that, and as we argued at that hearing, there are many ways of constructing a settlement. For example, the settlement funds can be paid by the defendant's purchasing annuity, and therefore the plaintiff is not, in that case, is not, an appellee here, is not directly getting the funds. They're flowing through an annuity that the defense purchases, and therefore obviating the impoundment of any funds that would be utilized that would be necessary to satisfy a charging.
As a non-party to the settlement, you believe that you have the right to tell the parties how to structure it?
What we are arguing, and as the Florida Supreme Court held in the Miller versus Scobie case that's cited in our brief, a charging lien confers standing on the Ambler Law Group.
Well, excuse me, that was cited in your reply brief, correct?
A charging lien.
You didn't argue that in your initial brief. That's something you didn't raise until your reply brief.
I think no, Scobie was cited in the initial brief. No. Scobie was
because I don't recall anything in the initial brief that asserted why you had a right to tell the parties how to structure their settlement.
Actually, it was Littman. Scobie is cited within Littman versus Fine that the charging lien confers standing to intervene in your own name as an interested party. So we were an interested party at the time we
Did you
filed.
intervene?
No, it's conferred by operation of law upon the filing of the notice of the charging lien in the pending action. And we filed the motion for enforcement of the charging lien prior to the hearing on the motion to approve the third settlement.
And is there anything that has occurred that will prevent you from enforcing your charging lien?
Yes, well, we don't know. Because of the denial of due process, we don't know if the full extent of the amount needed to protect the charging lien has been reserved by the court, because we had no participation in that hearing to know what those terms were, or to lodge in a meaningful way what the particular amounts were that and how they were being structured in a manner that would have offered an adequate protection. As Mr. Lilly had argued, there were approximately 5,000 hours that were the sum total comprising the charging lien, which could consist of anywhere.
Well, that's another thing you've glossed over, is the fact that I think the trial court determined that that provision in your retainer agreement was unenforceable.
Well, we did
The
seek
penalty provision.
So we did seek an interlocutory appeal, and that we were told it's a non-final order, and that still is an open issue and can be revisited. And we intend to have that revisited by the trial court based on the affidavit of Tim Chinaris, who said that there is no violation. But irrespective of that, the case of Shadris versus Yankakis at 668 Southern 2nd 186, the Florida Supreme Court from 1995 said that a quantum merit lien can be determined even if you have a non-compliant agreement, and the attorney is still entitled to the reasonable value of his service.
And I keep coming back to the same point. I sound like a broken record. I don't see anything that's occurred that will prevent you from enforcing your charging lien.
The question is,
your concern is whether there's going to be enough money to satisfy it.
My concern
That's a different issue than whether or not you have the ability to try to enforce it. And I don't see anything that's an impediment to that.
I think that the issue is casted differently in whether our vested property right has been diminished or diluted by the fact that the only thing that the charging lien attaches to are the funds that are essentially frozen and put aside until there has been a full and fair determination and adjudication of what the charging lien amount is. In this case,
have you cited any authority for the proposition that a party with a charging lien has the ability to have settlement funds frozen until their lien is determined, that you have the right to do that?
That is the nature of what the charging lien is, as opposed to a separate cause of action for example, breach of contract or quantum merit. The essence of what this court has held.
It would have been helpful to see some case law for this proposition.
For that proposition, we've cited case law that articulates the standard for what a charging lien is, as stated by the Florida Supreme Court and this court as well. And there was a case of Morgan and Morgan that was cited in the briefs that is that went to that point as well. But I thought we had cited a number of cases that articulate the proposition that the charging lien impresses upon the funds. In fact, there was the case that was cited in the materials here, that there is a vested right to an equitable hold on the settlement proceeds. And that was cited in the brief. I can get the court to that citation.
As you are approaching the 14th minute, you may want to take the opportunity to look for that case during counsel's response and provide it during rebuttal.
I think I will take that as sage advice, and I'll take a moment to look that up while I defer my time and save it for rebuttal.
You still have, some time left. You reserved 5. We're only at 14. Well, about 14 and a half now. I just didn't want you to lose it while you were looking.
Okay. The charging lien gives the attorney an equitable ownership interest in the client's cause of action, and the client's property right in his or her own cause of action is only what remains after the transfer to the attorney of the attorney's agreed on share. The citations for that are on page 11 of the reply brief.
Your argument is a violation of due process, not specifically targeting the amount of money that's being held. And so how are you denied due process? You weren't included in the original hearing, which I understand, but
Right.
you did file a motion for reconsideration. There was a hearing on that.
We still were required to argue in a vacuum. We had our blinders on because we still were not privy to knowing and to tender meaningful arguments about what was the terms of the settlement that was being approved and how those funds were being directed. For example, if they were being directed by a defense purchased annuity, they would be essentially depriving the plaintiff of those funds if they were going to be needed to be able to satisfy the totality of the charging lien, which has not yet been determined. So the due process violation.
Stop about there, since we're way past 15 now. I want to keep your 5 minutes left.
I'm sorry, I didn't.
No.
understand.
Is the answer complete? I don't want to cut you off short, but I don't want you, because I had promised to let you know.
No,
That's all.
I appreciate your letting me know. I'll go ahead and reserve my time, and if there's any further elaboration needed in response to Judge Rothstein Yoakum's question, I will address it then.
Let me stop this clock. Okay. Mr. Ruiz Carlos, you may respond.
Good morning, may it please the court. I'd like to start specifically with what is in the record, because there was some argument there by Mr. Ambler about a motion to enforce filed in 2020. That is not in the record on appeal before you, which is limited to the appendices that were in the briefs. What is in the record before you is only two operative documents. The first is the charging lien itself, which was filed in November of 2017, and that's in the appendix starting at page 35. And if you look at the notice of charging lien, it indicates that it is pursuant to the engagement agreement. There's no mention of quantum merit, there's no mention of amounts. The second operative document is the verified motion to enforce the lien, which is at the appendix starting at page 117. And if you look at page 118 and 119 of this verified motion, which Mr. Ambler swore to under penalty of perjury, he asserts that his claim is based on a provision of the engagement agreement, the contingency fee contract, that if the file is transferred or withdrawn from the attorney by the client, it is agreed that the attorney shall have a vested interest and based upon hourly compensation for all work performed, and it sets an hourly rate at $450 an hour. There is no mention of quantum merit anywhere within the verified motion. At paragraph 10.
Is it necessary that quantum merit be in the motion when it seems that from the Supreme Court's decisional law, when the trial court held that his contract was not enforceable, quantum merit stepped in as an equitable remedy to allow him on the totality of circumstances to either A, establish that he has a charge lien, and B, if so, then to seek an amount? Would that not be the correct process?
It is correct that as a principle of law, if the legal remedy fails, here the law provides an equitable remedy, which is quantum merit, but it nonetheless has to be pled. You can't have an unpled. All I'm pointing out to the court is that on the record before it, there is no quantum merit that has been pled by the law firm here. In paragraph 10, I would like to point out paragraph 10 of the verified motion, this is under oath at page 121. There is a statement that $1.3 million held in trust would be sufficient funds to cover the attorney's fees and costs under the charging lien. So there is, in fact, the only sworn proof before the trial court as to the amount that would be sufficient to cover Mr. Ambler's charging lien is $1.3 million. And that is at appendix 121. So regardless of what statements might have been made later after the fact, which, by the way, we're talking about, this filing was done in 2018. And in the interim, the record on appeal indicates that there's no billing records, no other sworn proof, no attempt whatsoever to try to verify the amounts of the billing or to assert any other type of claim. And what's significant, of course, is that that motion, that verified motion to enforce the lien, which is in May of 2018, the trial court determined that the contract was an unenforceable penalty provision violating the rules that govern our profession in August of 2018. And in that entire period of time, the record is devoid of any efforts to establish what the bills actually were, to make any effort to plead quantum merit. And I point that out because when we look at evaluating what the trial court did, this essentially is a due process claim by Mr. Ambler claiming that he did not have his due process rights because he didn't have an opportunity to present an objection to the court in this June 25th hearing. Now, the record actually reveals that he had the opportunity and did file 2 objections to the motion to approve the settlement. The trial court considered the objections and indicated that it considered the written objections. Then when he complained further, because he was concerned about jurisdiction, he filed a motion for rehearing that was heard within days. And so the trial court gave a meaningful opportunity to be heard with respect to the issues that were raised here. The objections that were filed on June 23rd and the supplement filed on June 25th, which are the appendix at 156 and 163, show that Mr. Ambler was given a meaningful opportunity to present his objections. The court, in its order at 250, in the transcript at 254, considered the written submissions. And there were only 2 requests that Mr. Ambler made, or Mr. Ambler's counsel made, at the hearing on the motion for reconsideration. The first is that the trial court retain jurisdiction, and the trial court made it clear that it was retaining jurisdiction. And Judge Kelly, to your point, there is absolutely nothing in the record that would prohibit Mr. Ambler from being able to litigate his lien. His concern is about the amount that's being held, and that's what was iterated at the motion for rehearing or reconsideration in his counsel's second request, which was that an additional $1.3 million be set aside. The trial court considered that and considered the sworn proof that was before him, which is only that verified motion that Mr. Ambler filed in 2018, and made a determination after asking counsel to verify precisely how much was in their trust account. And there was $1,500,000 and change in the trust account, which exceeds the 1.3 million of which there was sworn proof. So the court determined, without determining the actual charging limit, determined that there appeared to be ample security. That type of a factual determination is, of course, supported by competent substantial evidence. It's the only sworn proof that there was before the court. The other issue, I guess we should discuss, since this is all framed as a due process claim, it's important to recall what the standard of review is on a due process claim. The cases that were cited in the initial brief by Mr. Ambler are Second District Court of Appeals decisions. Henderson versus Lyons and Douglas versus Johnson. Judge Kazam wrote both opinions. And another one of the cases that was cited by Mr. Ambler, which was Carmona versus Walmart Stores East, which is also from this court in 2011. And although Judge Kazam wrote that one as well, Judge Kelly, you and Judge Casanueva were also on that panel. And you all determined that the appropriate standard of review is abuse of discretion on a due process challenge for a failure to have an opportunity to be heard. So the question is whether or not the trial court abused its discretion in what Mr. Ambler's asserting, not having an opportunity to assert its objection. There's absolutely no case law that supports the concept that Mr. Ambler is entitled to appear at this motion to determine the settlement. It was not resolving his charging lien, and he was given an opportunity to present his objections without disturbing the confidentiality of the proceedings by filing his written submissions. What's more, it actually appears from the record, and this was what the judge recalled, and it's undisputed in the record, and this is at Appendix 254 on the hearing transcript, that originally the hearing that Mr. Ambler is complaining about not being allowed to attend was scheduled to be heard in chambers. This is during, I guess, the midst of the pandemic. And it was moved, in courtroom, and then it was moved into chambers. And at that time, a phone number was disseminated. And Mr. Ambler actually called into the judge's private line for the hearing. And he was told that he was there as a party and to have his attorney, to pass the phone number on to his attorney. And apparently he didn't do that. There's no indication of what occurred, but the judge recalls Mr. Ambler being present at the hearing, but as a party without an attorney at 254 of the record. So there's even a hint there in the record that there was notice that the hearing was going on. And of course, he had the opportunity to submit his written objections. They were considered by the court, and the court dealt with his concerns and affirmed both that it's retaining jurisdiction and that there's sufficient security being held in trust to preserve whatever charging lien he might assert with respect to what there was already sworn proof as to how much the charging lien was.
Counsel, if I could go back to your last comment about
Yes.
that there was a sufficient amount being held. I would like to borrow Mr. Ambler's statement about the cart before the horse. And I beg your indulgence, see if I can phrase this as an articulate question for a change so that maybe Mr. Ambler can respond as well. As I look at Judge Day's order on enforceability of fee contract, my eye was focused on paragraph 2. And after vacating the order, it says, if so, whether the Ambler Law Group is entitled to any recovery in quantum merit. Is there a difference between a theoretical entitlement and an established entitlement? To see if I can give some structure to my concern is because there has been no hearing to determine A, entitlement, and B, the amount of the lien. Is there any due process right that has accrued other than a theoretical one that says, assume I prevail and assume an amount's given and assume that it's less than the amount? And my concern is with the word, and if I'm using it correctly, assume, because as I look at that, Judge Day is saying, I haven't yet determined whether or not his claim of lien is valid. And then I would have to do that first in order to decide what is the reasonable amount in quantum merit, assuming that we get there, and then consider the totality of circumstances, and then determine the benefit to the client and all those things. And so my concern is, as I'm looking at due process, usually you're saying you have some sort of right. And I'm wondering if to have the right, there needs to be an assertion by the court of a legal entitlement and a legally determined amount.
Well, your question raises more questions than I may even have answers.
And that's a good thing that I'm sitting where I sit, because I get to ask them. And only later will I have to necessarily answer them. But I wanted to give each counsel a chance to say whether I'm going down the wrong stream of jurisprudence, a right stream, or it's not ready, it's whatever they are. But, I kept looking at that, and I'm looking at due process and an entitlement to hearing, and what right has yet been established. There seems to arguably, if I'm Judge Day, a bare claim of a lien.
And
that may be sufficient for our purposes.
You're correct that there has yet to be an establishment to the entitlement of a lien, right? And the determination, the assertion that was made in the pleadings before Judge Day were based on the contract, which was, there was a determination that the contract was void and unenforceable. But there's still the potential, although it's unpled at the time, for there to be an equitable remedy of quantum merit. The issue is from a let's be as protective as possible of the potential for a property right. This is really a contingent, unliquidated, unestablished right at best, right? Because it may well be that it fails. If the contract fails, there's all kinds of factors that have to be determined to determine whether or not quantum merit is appropriate and what the amount of quantum merit is. But be that as it may, even if that right is not ever going to be established, the court here had before it sworn proof as to what the outermost limit of what that lien could be. Because balancing the interests here, the court also has an incredibly injured individual who's the plaintiff, and these are funds for his care and treatment that are necessary for his care and treatment. And he's trying to balance, well, some funds have to be dispersed for this versus this lien that's been asserted. And the only sworn proof that's before the court is the outermost limit, that ceiling is $1.3 million. So he's not making any determination as to the validity of the lien, how much the lien might ultimately be. Ultimately, there may be no lien. It may be a zero, or ultimately maybe $100,000 that the court makes that determination. But what he had before him when he made a determination here with respect to the settlement was there's sworn proof that the outermost limit is $1.3 million. So to the extent
and quantum merit, even if he does have an argument for quantum merit, that's still limited by the maximum amount provided for by the contract, right? And so if the only evidence before the court is that based on our prior hours and the amount we charge per hour, it will be this much. I mean, that's what you're saying, right? I just want to make sure. Okay.
Exactly. And frankly, that's all that's been asserted by Mr. Ambler in the pleadings that were before the trial court were use this hourly calculation and here's how many hours I have. What he asserted was less than the $1.3 million, to be sure. He actually laid out some sort of preliminary calculation for hours in that same verified motion, but then said, to be safe, let's make it $1.3 million that's held in trust. So that's where that number is coming from. So that's what in the court. Sorry.
In the motion,
even assuming A, B, and C, this is the worst that could happen, even if he meets all his ducks in a row, so to speak.
Exactly. And so without deciding it, that's why he was, and that goes to the question of there's nothing that's preventing Mr. Ambler from litigating his lien, which was Judge Kelly's point.
Two things I wanted to ask you. In the motion for consideration, I think that's where he raised the issue of actually our lien is going to be around 3 million or so. That wasn't verified, was it?
It was not verified.
Okay, let me wait. Second part of that question is, had they appeared at the hearing to approve the settlement, would they have had the ability to introduce sworn testimony as to what they thought the amount of their lien was going to be to increase the amount over the previous amount they had attested to?
No, nor have they made any arguments to that end.
No, I know. I'm trying to understand what they lost by not being at this hearing. So
yeah, nor frankly, guessing. You know, even at the motion for reconsideration. So you're wondering, well, here they file a supplement and they're trying to object to the confidential settlement. And yet even then there's still no sworn proof, no affidavit, nothing that says this is the amount. Even in that,
they just threw a number out based on a theory that the trial court had already rejected.
They threw 3 numbers. They said somewhere between 2 to 3 million. And then they said, but just give us an additional 1.3. And then that's what, at the motion for reconsideration at the hearing, Mr. Lilly argued, please just give us an extra 1.3 in trust. Yeah, without any proof or basis for it. So just summing back up again, under the abuse of discretion standard, Mr. Ambler had an opportunity to be heard. His arguments were presented and the court has retained jurisdiction. There is no impediment to his ability to litigate his lien, and the court on the sworn proof before it relied on competent substantial evidence in determining that there was ample security there for this as yet to be determined lien without adjudicating whether or not there even is an actually valid claim here for quantum merit. Unless there's any further questions, thank you all. We'd ask that you affirm.
Thank you.
Thank you for allowing me to use my technological skills and stopping time from running. And now we can start with rebuttal. With a clear slate, you have your 5.
Thank you very much. Thank you very much, Your Honor and judges. Let me address a couple of things. First of all, a couple of misstatements. At the hearing that the court held, I actually dialed in on the judge's private line, and the transcript reflects that I told the judge that I have my counsel and a court reporter on the line, on another line that public line that we're told to call in, and I was told to hang up and that they were not, and I was not allowed to be participating in that hearing. So I just want to be clear, that's what the transcript shows on that point. To Mr. Ruiz's comment about the quantum merit, the Shadris versus Yankakis case, which I cited earlier, which was the Florida Supreme Court case from 1995, addresses the idea that quantum merit would apply as an equitable remedy, even if you have a non-compliant agreement and the attorney is still entitled under the authority of that case to a reasonable value of their services. So it is still an open question as to whether that was a non-compliant agreement or not, but right now, taken as the record is, it is considered one, and so the Ambler Law Group is entitled to a quantum merit recovery under the authority of Shadris. The important thing is that our jurisprudence and the second DCA has held clearly that a charge is vested by the notice that is given, proper and timely notice that is given by a party of the assertion of the charging lien. That occurred on November 15th. of 2017. The verified motion was filed in May of 2018. The hearing that we're complaining about was 2 years later in 2020. Appellee
But Mr. Ambler, do you disagree that quantum merit would be limited to, I mean, it's still limited by the terms of the contract, correct?
You know, that's hard to say. If the contract is void, as Judge Day found, then I don't know that you are limited by the contract. You're limited to the principles of quantum merit. I think that's an unsettled question of law, but even assuming that you are limited to the terms of the contract, there's been no determination that the amount of recovery under the contract collectively for the 3 settlements is going to be sufficient.
Well, and that's what I'm wondering, because you're relying on the 3 settlements, but pursuant to the terms of your contract, if you were, if the plaintiff selected different counsel during the proceedings, per your contract, you were still entitled to the reasonable value of the services that you had already provided. So basically, my understanding of your contract, it would transform it from a contingency to a straight up calculation of hours and hourly rate. Is that not correct?
That is not quite correct under the Florida Supreme Court case of Shearsea et al. Versus
I'm just talking about the terms of your contract.
Right. But the lien, but the issue is under a valid charging lien, it's determined by the totality of the circumstances for quantum merit, not just based on a lodestar. So if the contract has both contingency and lodestar elements to it, and it was a hybrid contract for both non-contingency work that was done for non-contingency related issues dealing with non-malpractice things like retirement benefits and guardianship matters and stuff, as well as contingency matters. But at this point, given the status of the record, it's just an open question still. It's an open question that's determined by quantum merit, but it is not a question, as Judge Casanova was trying to get to in his earlier question to police counsel, that it's not an esoteric argument of whether there's entitlement or not. The charging lien becomes a vested right upon timely proper notice to the opposing side and to the court, which occurred. And then there was a verified motion early on in 2018 that was trying to preserve an amount relative to the second settlement. There was a big footnote that's been missed here on page 120 of the appendix, where it talks about these were preliminary calculations that were made. It discusses that issue in great detail. And to roll forward 2 years later, at the time that we had not yet had an evidentiary hearing on the charging lien, it was pointed out at the motion for rehearing that the calculations were at about 5,000 hours, which was higher than the amount 2 years earlier. And the explanation for that is in there. And there's no requirement for those hourly rates to be predetermined and to operate as a ceiling. The quantum merit, again, based on totality of the circumstances, is not just a lodestar. It is the totality of your contribution to the ultimate outcome in the case. All of those things would be determined at an evidentiary hearing, a hearing that we have not had yet, and therefore determining the propriety of distributing funds, any funds to the plaintiff, which by releasing those funds diminishes the value of protected funds that the Ambler Law Group would have a potential claim to, is the heart of the due process violation. It's not.
So you were trying to
let Judge Rothstein Yoakum ask a final question, since we have passed through the time barrier. And before she asks a question, I will let you know that I noticed in Judge Day's order there was nothing invalidating the lien. I was waiting to see if anybody brought that up, and I will be sure to share that with Judge Casanova. Judge Rothstein Yoakum.
It just seems to me that you were trying to turn what you're saying is you were not permitted to turn the hearing on the third settlement agreement basically into a hearing on what you think is an appropriate amount to be held in the law firm's trust account. And what I'm wondering is whether you had an obligation while any of this was ongoing to bring to the court's attention before that what was in the trust account was not going to be sufficient to cover your reasonable expenses.
Well, short answer to your question, we attempted to make that known to the court before the hearing on June 25th that it was not adequate, the best we could, but we were doing so in a vacuum. We weren't required at that point because we hadn't completed discovery that the court had ordered, and that's a whole separate issue, but discovery had not been completed on the issue of the charging lien, the information we were trying to obtain to be able to close that door and pin all those numbers down. So we were arguing from the facts that we had at that time that the court needed to impress upon all of the funds that were there and proceed with the determination of the charge lien at the evidentiary hearing rather than going ahead and approving any disbursements. You can approve the settlement, but not approve disbursements from the settlement pending the resolution of the charging lien. That's where we were denied our meaningful opportunity to be heard. And that's what this court in the Carmona versus Walmart case in 2011 said, that due process requires not just the notice, but the full and fair opportunity to be heard at that hearing. And we couldn't lodge any objections when we didn't know the nature of what the terms and conditions of the settlement were in order to fashion and articulate our objections at that hearing.
Okay.
And for those reasons, we asked the court reverse the order of the court of June 26th and either withhold disbursement of the third settlement funds or order that they be disgorged and held in the registry of the court or in the trust account of the appellee's counsel pending a final determination of the charging lien. Thank you for your time.
Counsel. It's been an interesting discussion today. I thank you for your indulgence, in helping us along with some of the various issues that permeated around this case. I appreciate it very much, and I'm sure the panel does as well. We wish you safe travels and good health, and I will let you transfer back.
Thank you
wherever
so
it is.